Morning, Council. Nice to see you both. We will call the next case, which is People versus Allen. It is also a mini oral argument on the application, which means you each have 15 minutes. Ms. Ponce, you may reserve some. We ask you to try and manage that. You may proceed.
Thank you. Good morning, Your Honors. My name is Lindsay Ponce with the State Appellate Defender's Office, and I'm appearing on behalf of Mr. Erick, Rosean, Allen. The holding in People v. Edziak fails to account for the realities of Michigan's parole process, namely that parole detainers aren't always issued when a parolee is arrested for a new offense, as was the case with Mr. Allen. Rather, a parole agent who arguably knows the parolee best may decide that violating the individual's parole does not serve the goals of rehabilitation, or decide to defer to the circuit court process rather than initiating a parole violation process. Whether a parole detainer is issued is paramount to whether the parolee is entitled to jail credit under MCL 769.11b. When there is no parole detainer, the parolee can post bond and go home if he or she has the means to do so. However, those parolees who do not have the means to post bond will remain incarcerated due to an inability to furnish bond. If a parole detainer is issued, the parolee will remain incarcerated irrespective of whether he or she can post bond. Ultimately, the presence or absence of a parole detainer is what determines whether the jail credit statute is applicable to a parolee. It is also what determines whether the rule in Edziak applies. This court should hold that Edziak does not apply to parolees for whom a parole detainer has not been issued, and hold that those parolees are entitled to jail credit under MCL 769.11b. Such a holding is consistent with the plain language of MCL 769.11b and with this court's opinions regarding Michigan's jail credit statute. And at this time, I am happy to answer any questions that the court may have.
Thank you. Let me see who has questions. We'll start with Justice Bernstein.
I'm sorry, I wasn't quick enough to unmute, but he has no question.
Okay, no problem. Thank you. Justice Clement?
No questions at this time. Thank you.
Justice Kavanaugh?
No questions for me.
Justice Welch?
Yeah, I have a question. One thing I'm wondering, assuming this court were to agree with you, in this instance, it's my understanding that the sentencing court sort of took the client's time served into account when he was actually sentenced. So I'm wondering, how do we get to prejudice in this particular case?
Well, first of all, I think the court did say that he was taking some of the time that he had spent into account, but however, it was unclear, at least in my opinion of reading of the record, exactly how much time. He mentioned that he had spent about 8 months in jail, so he was using some of that. But I think really we get to prejudice because in this situation, not giving Mr. Allen the credit really creates an unfairness, because the bigger picture is that when it basically creates a discrepancy between parolees that are poor and parolees that have means to pay bond. And so in Mr. Allen's case, he didn't have the money to pay the bond to go home. Had he had the money to pay the bond, he would have gone home. And so the time that he did spend incarcerated, he, as someone who had means, would have been out, would have been home. And so while the judge did say, oh, I'm giving you some credit, that doesn't follow what the jail credit statute says, and that doesn't follow what the rule should be, that when there's not a parole detainer, they should get credit, irregardless or irrespective of the judge saying, well, I'm giving you some credit here.
Thank you.
Thank you.
Counsel, is it your view that we would have to disrupt Edziak in any way, overturn it, or do you view this as not sufficiently covered by Edziak, and you're asking for more of a clarification?
Your Honor, I would say this is a clarification. I don't think you need to disrupt Edziak or overrule it. This is essentially a situation where the rule in Edziak simply doesn't apply, because in Edziak, the opinion is based on if someone, a parolee, when they're arrested for a new offense, resumes serving their earlier sentence and therefore remains incarcerated regardless. But what that doesn't cover is a situation like this, where there is no detainer. And so a parolee that can post bond can in fact go home and will not be incarcerated if they can post bond. So this doesn't have to be a situation where you have to disturb EDSIAC. Rather, it's just simply a clarification that EDSIAC simply isn't applicable here.
Thank you. Justice Zaro.
Thank you very much. No questions at this time.
Justice Viviano.
Yes, thank you. I guess I just have one question, which is, before this case, this Court of Appeals decision in this case, was this issue ever really contested in the lower courts? In other words, did prosecutors object to this? It seems like the prosecutor in this case conceded below, although they're taking a different position now. But in sort of my vague recollection of my days as a trial judge is that prosecutors would not contest the notion that defendants would be entitled to jail credit if there was no parole detainer. Do you have any insight on that for us?
Well, I don't often practice in the trial court, but what I can tell you is I do know that other colleagues in my office have gone into the trial court to correct this issue, and trial court judges have agreed, yes, there wasn't a parole detainer, so they should, get the jail credit. So I think that Your Honor is probably correct that that this is something that there are times where the prosecutors or the trial courts agree and say, yes, clearly EDSIAC doesn't apply here because there was no parole detainer.
Well, I guess I would say this. I think Judge Weiper's interpretation of EDSIAC was fair because EDSIAC has very broad language that on its face would apply to this, would apply here just because the language was so broad. But the facts of that case are distinguishable because there was a parole detainer. Isn't that a better way to describe what happened here? I mean, in other words, the lower court, I think, conscientiously applied EDSIAC, but the problem is that the EDSIAC's language is overbroad.
So I think yes, EDSIAC, I think you can look at it that way, Your Honor. I think you could look at it being overbroad, but I think if you read into EDSIAC, I think it's the very, very first paragraph of EDSIAC where the court goes into, we hold that the jail credit statute doesn't apply. I'm not quoting, I'm paraphrasing, but essentially because a parolee will remain incarcerated regardless of their inability to furnish or post bond or denial of bond. And essentially that presupposes that essentially anytime a parolee is arrested on a new offense, that there will be a parole detainer. And so I think, yeah, you definitely could say that the language of EDSIAC is overbroad, but I still think by reading it in conjunction with the plain language of the statute, one can still come to the conclusion that the jail credit statute simply doesn't apply in a situation such as this.
Okay, thank you, counsel.
Thank you.
I did it myself. I can't believe it. Would you like to continue or would you like to reserve time for rebuttal?
Your Honor, I will reserve my time for rebuttal. Thank you.
Okay, no problem. Ms. Gibson Goodenough.
Thank you so much, Judge. Good morning, and may it please the court. My name is Alexis Gibson Goodenough, and I am from the Monroe County Prosecutor's Office on behalf of the plaintiff appellee. For purposes of oral argument, the first issue that I will address is whether or not EDSIAC was correctly decided. In this case, I would submit to the court that it was in fact correctly decided. And considering the historical progression, and I think that was just discussed a bit on appellant's, some of the questions that she was receiving, and looking at the historical progression to the point where we got to EDSIAC, looking at the legislative intent behind the jail credit statute, really the purpose was to ensure that there was no disparity among defendants and their ability to furnish bond or not. But ironically enough, this was somewhat addressed in the Prescurn decision, where the court found that to attribute that the legislature had the intention to award a defendant credit for a subsequent offense committed while he was out on bond is to attribute that the legislature had an intent to afford a defendant a, quote, free misdemeanor, one for which there is a sentence or confinement not need be served. And I think that's really a salient point, even up and through the EDSIAC decision, that The purpose of the jail credit statute was to ensure that there wasn't disparity among ability to furnish bond, not to afford the defendants the opportunity and the relief sought or relief intended by the jail credit statute. And that's why IDSIAC is still a salient point and was correctly decided, because even when we extend it even further to parolees, not just those out on bond, and this moves into the second portion of the argument that it does in fact apply to individuals who are on parole absent a detainer, that the premise is that the jail credit statute was intended, again, to minimize the disparity here, not to allow an individual or afford a defendant a quote free sentence for when they're out free and clear, or out on parole rather, or out on bond, the opportunity to obtain jail credit against their original sentence. And I think IDSIAC was quite clear that you look at cases such as Cedars or Philippe, where they were seemingly contingent upon a parole detainer. IDSIAC took a step back, and this court essentially said that the jail credit statute is not applicable, because the second that this individual who is on parole gets picked back up or reincarcerated, their time begins. That unexpired time begins. So for that reason, I would argue that not only is it correct, but it's applicable in this particular situation. And ironically enough, in footnote 13 in the IDSIAC decision, this court acknowledged that the prosecutor pointed to the fact that there's not always a parole detainer in place. And this court cited back to MCL, excuse me, I want to make sure I get the site correct, 791239, pointing to the parolee may still be arrested without a warrant and detained if there are reasonable grounds. So that
Counsel, let me just interrupt you. I don't want to use up all your time without making sure you have a chance to answer everyone's questions. So I'm sorry to interrupt. But yeah.
No, please do.
Okay, Justice Bernstein.
I want to delve in. Good morning, counsel. I want to delve into this issue that I think has been raised, and you addressed it briefly, but I do want to kind of get into it. How do you respond to the issue that, based on the socioeconomic situation of this individual and the individuals that have come after him, that that this could have a real implication on people as it pertains to kind of incarceration before trial?
Thank you very much. And the first thing I will point to is the salient point that this individual was actually granted bond on 2 different occasions prior to the time that he was eventually unable to furnish it. So I do understand that there is, unfortunately, inevitably going to be an issue of disparity at some point. But I would point to the fact that the trial court is, as in this case, was cognizant of that fact, that there are going to be defendants that are not going to be financially available. This defendant was provided a reasonable bond. Actually, his first bond was a PR bond, and he was released into a treatment program. So I suppose, I'm sorry, I didn't want to interrupt you, Justice Bernstein. I didn't know if you had a further query.
No, I didn't. I wasn't. I wasn't. I actually wasn't saying anything. If you please continue.
Okay, thank you very much. Sorry, the feedback. I just wanted to make sure I wasn't. I'll talk forever. But really, I think that the trial court is frankly quite cognizant of that fact. The jail credit statute is quite clear. But when you have a parolee that continuously engages in criminal behavior, even though bond has been provided twice, we might be even in a different situation if bond wasn't provided at all, but that's not the case here. So I think trial courts will continuously be cognizant. The jail credit statute it is clear, but in terms of parolees, it's I think that we just have to continually defer to the trial court and their discretion based on the individual basis.
Counsel, thank you very much.
Justice Clement.
No questions. Thank you.
Justice Kavanaugh.
No questions.
Justice Welch.
No questions.
Justice Zard.
No questions. Thank you.
Justice Viviano.
All right, I have no questions.
Okay, you have some additional time, counsel. You can return to anything you want to make sure we hear, and I leave it to you.
Thank you very very much, Justice McCormick. Just briefly, actually pointing to Justice Viviano's point regarding, I searched high and low for a case where there was a detainer not put in place. And I think that this is an issue that, as we've seen in the issues eventually leading up to IDSIAC, and even in the Court of Appeals decision in this particular issue, it's not a common occurrence, but it does in fact happen. I do believe that the IDSIAC decision confronts that and speaks to it, albeit perhaps not in a direct way, saying that a detainer is or isn't necessary. But again, fundamentally going back to, I don't want to say the bright line rule, but essentially the bright line rule that this decision states that an individual, the second that if they are on parole, they get reincarcerated for an unrelated crime while on parole, they automatically go back to serving out the remainder of that sentence. And I would also point to the fact that the 1988 amendment of MCL 768.7A2 also provides a little bit of relief to these individuals. I know that there's inevitably always going to be a concern that incarceration will just, continue forever. And I actually think that that was a quote in the Prescuren matter that was a concern. But there have been statutory amendments that allow individuals, even if they are on parole and subsequently engage in further criminal behavior, there is relief available to them. Not as much relief, but there is a statutory provision that engages them and ensures that their sentence is still fair. And finally, just briefly to Justice Welch's point, there is no substantial prejudice here. This individual, as I indicated, had multiple opportunities while on parole. He was released on a PR bond. He was given the opportunity for treatment. This is not a case where the trial court didn't take into account the pitfalls of addiction and the concerns that came along with that. This is a case where the trial court continuously attempted to accommodate the individual and ensure that he was given, if you will, a fair shake. So if there are no other questions, I will turn the floor back over to my opposing counsel.
Thank you very much. Ms. Ponce, you have some rebuttal time.
Thank you, Your Honor. I would like to point out, my sister counsel pointed out footnote 13 in the IDSIAC decision. And while that is correct that there is a mention about how the prosecutor stated at oral argument that the MDOC doesn't always issue a warrant, the court in that footnote after that sentence pointed out that while that may be the case, a parolee may be arrested without a warrant and detained if there are reasonable grounds to believe he has violated his parole. And so I would argue to this court that that is an indication that the court in IDSIAC was still under the impression that once someone is arrested on a parole violation and is sitting in jail, is not going to be able to get out because there is going to be something holding them there in addition to any kind of bond that may be set.
Counsel, let me just jump in because I was thinking about that footnote too. Isn't there a distinction between a warrant that the MDOC that they're able to issue an arrest warrant, which they don't even need to go out and pick up somebody who's on parole because they can arrest them, I think, without a warrant. I think the statute allows if there's reasonable cause. Isn't that a different situation than someone who's picked up on a different charge by a different agency? And then the MDOC puts a detainer, files a parole detainer with the law enforcement agency holding that person?
It is a different situation. When there's a warrant issue just for a parole violation, and my understanding is a lot of times that may happen if it's a violation that may be a technical violation or maybe a violation that isn't necessarily a new offense, so that a warrant will be issued or they can just be arrested. In a case where someone commits a new offense, they're arrested presumably by police officer, the sheriff's department, and they're arrested and in jail because of that defense. And then if MDOC or their parole agent wants to ensure that they remain incarcerated, regardless of if they can make bond, then a parole detainer is put on them to say to the agency holding them, hey, even if this individual makes bond, don't let them go. And so that is kind of demonstrates the point of why whether or not there's a parole detainer is so important in determining whether or not the jail credit statute should apply. Because if there is no parole detainer, there's nothing holding them except for the new charge and the bond. If there is a parole detainer, even if they make bond, they'll still remain incarcerated.
All right, thank you, counsel.
Thank you. I would also note that with regard to this whole issue, a lot of what my sister counsel talked about, and there's a lot of talk in both EZIAC and the briefs about the MDOC having continued jurisdiction over someone who's on parole, and once they're arrested, them returning or continuing to serve their remaining prison sentence. And I would just note again, if there is no detainer and they do post bond, then obviously they aren't serving their prison sentence because they're at home. And so I think it's an important distinction between being under the jurisdiction of the MDOC because you're on parole, and actually being held in jail on a parole detainer, where even if you could pay the bond, you would still remain in jail. Ultimately, this all goes back to the plain language of MCL 769.11b, and I would ask this court to hold or simply recognize that in a situation where, as in Mr. Allen's, a parole detainer wasn't issued and he was being held simply because he couldn't make the bond, that the rule in EZIAC simply is not applicable and the jail credit statute is applicable. And unless this court has any other questions, I will rest.
Thank you. Let me see if anybody has any follow-up questions. Seeing none, thank you both for your excellent presentations, and the case will be submitted.
Thank you.